Hi, everyone. I hope you're all keeping well, safe, healthy, and sane in these difficult times. Thank you for joining our Policy Lab today on Palestine's case at the International Criminal Court. Just a brief historical background before we start the discussion with our speakers. In 2009, following Israel's war on Gaza, the Palestinian Authority approached the ICC to ask for an investigation into Israeli war crimes. However, since Palestine was not considered as a state, it was told that it could not become a party to the Rome Statute, which is a requirement for the court to have jurisdiction over the Palestinian territory. And so Palestinians went to the UN to be recognized as a state and thus become party to the Rome Statute. And in November 2012, the UN General Assembly passed a resolution recognizing Palestine as a non-member observer state. In January 2015, the government of Palestine acceded to the Rome Statute, and the prosecutor announced the opening of a preliminary examination into the situation in Palestine in order to establish whether there was a reasonable basis to believe that crimes within the jurisdiction of the court have been committed in the occupied Palestinian territories. But in May 2018, because Palestinians felt that the preliminary examination was taking too long, they made a referral to the court, calling on the prosecutor to open an immediate investigation. And finally, it was on the 20th of December 2019 that the ICC prosecutor announced the conclusion of her preliminary examination and stated that there is a reasonable basis to believe that crimes within the jurisdiction of the court have been committed in the West Bank, East Jerusalem, and the Gaza Strip. However, the prosecutor requested a ruling by the pretrial chamber to confirm the court's territorial jurisdiction over the occupied Palestinian territories. And as a result, the court invited submissions from the general public, from states, NGOs, academics, and individuals as to the territorial scope of the court's jurisdiction in Palestine. About 40 submissions were sent to the court, including one written by Halla Shoaibi, who is with us today. It is yet to be seen what the pretrial chamber would decide, so this is where we are now. And against this background, in this policy lab today, we would like to talk more about the status of the situation currently pending for the court and the limits and prospects of an ICC investigation. So to discuss these issues, we are very happy to have with us today Halla Shoaibi and Ardi Imseis. Halla is currently the chair of the law department at Birzeit University, and Ardi Imseis is assistant professor of law at Queen's University. And I am Noor Arafeh, and I will be facilitating this policy lab. I'm going to start with you, Ardi. Can you tell us about the status of the situation today, what is being examined, and what's the examination process like?
Absolutely, Noor. Let me thank you and all of those who are participating as well, and thanking Halla for joining us today and for this opportunity. I guess the best place to begin is to appreciate the process that would normally be involved in any case, in any situation before the International Criminal Court. It's typically a 6-step process. Things begin with what we call a preliminary examination, during which time and through which the Office of the Prosecutor examines whether there's sufficient evidence to proceed with the second stage, which is an investigation proper. The investigation takes place, evidence is culled, put together, and if there's a determination by the Office of the Prosecutor that there's enough evidence to proceed with a trial, it will go to pretrial phase, eventually reach trial phase, and then finally, if need be, an appeal. And then ultimately, when that is through, some form of enforcement will be undertaken. I think it's important for us to appreciate, as we consider the situation in Palestine, that the timelines on this process are not limited. There is nothing in the Rome Statute that requires, for instance, a preliminary examination to be complete by any given period of time. And that's why it's taken now, 5 years or so, for the Office of the Prosecutor to complete her preliminary examination. There was a great deal of concern by members of civil society and victims advocates that the preliminary phase was just taking far too long. And as you'd mentioned, the state of Palestine had tried to urge on many occasions the Office of the Prosecutor to move on, including through making a specific referral in 2018 to sort of push her on. We were all rather delighted when we found that her decision taken in December 2019 was that indeed the preliminary examination had been complete, and indeed there was enough evidence to proceed, in her view, to an investigation. Where are we today? Well, as you'd mentioned, the Office of the Prosecutor has sought a ruling, an opinion, an affirmation, really, of her own view, which she put to the pretrial chamber, basically to the court, on the question, a simple question of what is the territorial scope of the applicability of the governing statute of the International Criminal Court, the Rome Statute. Basically, what constitutes the state of Palestine? Because if in any prosecution, the prosecutor is going to need to undertake work, but it's going to necessarily be limited by subject matter, in this case, core crimes, right? Genocide, crimes against humanity, war crimes, etc., but also by a territorial element, that is, the territory of a signatory state. In this case, the state of Palestine has acceded to the Rome Statute, and the question that she had and is seeking an opinion from the court on is what is the territorial scope of the application of the Rome Statute. In her opinion, which was a very, very long and well-drafted opinion, she made it clear that her position is sort of, if you like, in two stages, right? She's taking two positions, one primary and one alternative. The primary position, which I think is the strongest position, is that there's no need to assess whether or not Palestine is a state. In fact, the train has left the station on that. Why? Because the state of Palestine has already acceded or signed on to the Rome Statute, and it would be incongruous and also ultra vires, or beyond the power of the court, to, after the fact, question the validity of a signatory, of a signature and an accession and a ratification of a member state, right, of a state party. This, you can imagine, would throw international law, leave aside the ICC and the Rome Statute, into complete disarray if states, when they sign on to treaties, will have the validity of their signature ex post facto questioned by, a governing authority of the treaty or what have you. So that's the first position. But her second position is, look, even if Palestine's standing as a state for the purposes of the Rome Statute can be impugned or questioned, Palestine still qualifies as a state under general principles of international law. And these principles are rooted in what we call, the international lawyers call the Montevideo Convention, which is an archaic convention from 1933 that sets out 4 criteria for statehood in international law. The criteria are: 1, you must have a permanent population; 2, you must have a defined or relatively defined territory; 3, you must have a government; and 4, you must have the capacity to enter into foreign relations, right? And if I've just recently written a paper on this, and I'm writing a book now on the United Nations and the question of Palestine, in which this matter figures prominently. But if you look at the state practice around the application of the Montevideo principles, and for that, we go to the United Nations admissions practice, right? Admissions of states to the United Nations for membership in the United Nations requires that these entities are indeed states. And that's the best place to look for this practice. And looking at the practice, you see that states have historically, over the past 70 years, applied a very liberal, flexible, and permissive interpretation of these 4 Montevideo criteria, to the point where, for instance, states that have no fixed borders, that does not impede their claim to a defined territory sufficient enough to satisfy the Montevideo criteria. Or states who are embroiled in hot civil war, right? The Congo, 1960, where 2 parties are vying for control through a civil war, claiming each of them the right to be recognized as the effective government in the territory. Even those types of situations have not been enough to vitiate claims, in that case of Congo, that they had sufficient enough government to satisfy the Montevideo criteria. All this to say that, objectively speaking, it is the view of many scholars, although it is debatable, but not in my particular view. I take the view that Palestine does satisfy the Montevideo Convention criteria, and indeed so too does the Office of the Prosecutor as her second alternative position. So she's put these two positions to the court, is asking the court to affirm her view that the territorial scope of the Rome Statute's applicability is indeed the occupied Palestinian territory, as affirmed in countless resolutions of the General Assembly of the United Nations, the Security Council, the International Court of Justice, and so forth. And we're just now waiting to hear back from the court on what its view is.
Thank you so much, Ardi. So Halla, you recently wrote with Dr. Assam Khalil, an amicus curiae to the International Criminal Court, on the issue of whether the Oslo Accords prohibit the exercise of the court's jurisdiction on Israeli nationals, which is a claim that is widely used by Israel. Can you tell us more about this and the potential limits of Oslo, and how you provided a counterclaim to the limits of Oslo?
Sure. Okay, so according to the Oslo Accords, Palestinian courts are not allowed, or basically they don't have any jurisdiction over Israeli citizens. So basically, if an Israeli national commits a crime on Palestinian territory against a Palestinian national, Palestinian courts are not allowed to prosecute this Israeli citizen. Accordingly, what basically is done on the ground is that the Palestinians, even if they capture this person, they have to give him basically back to the Israeli authority. Accordingly, the Israeli Attorney General and other Israeli or American scholars argued that since the Palestinians are not allowed to prosecute the Israelis, Palestinians are not able to delegate this jurisdiction to the court, to the ICC. Basically, it's the idea that you cannot give what you cannot have. You cannot delegate a power that you don't own by yourself. Mm-hmm. However, we argue in our amicus, Hassan and I, we argue that this is not exactly true in this case. Basically, to begin with, the idea that the Oslo Accords does not allow Palestinians to prosecute Israelis is an issue of that. Sorry, I'm sorry. Can you hear me? Because I can't see.
Yeah, we can hear you. Even if you can see us, Halla. Halla, we can hear you. Even if you can't hear us, that's fine.
Okay.
Yeah. But we can't see you, but that's also fine. Yeah, we can see you now.
Okay. So this argument, basically what they try to do, they try to presume there's an exact symmetry between domestic criminal jurisdiction and that of the ICC. It presupposes that the ICC can extend its jurisdiction only to situations where the entity in question has an identical jurisdiction to that of the ICC. However, this is not accurate because it's not uncommon that a domestic jurisdiction may not criminalize a conduct that is classified as a crime within international law or within the Rome Statute. So in fact, the court, the ICC itself, was established to fill in accountability gaps and hence to end impunity. So to begin with, this whole argument is based on the idea that there should be symmetry between national and international law is not very accurate. Most importantly is that the Oslo Accords, even if they bar Palestinians from exercising their jurisdiction over Israelis, they do so only within this time frame, within the time frame of Oslo, and not as an issue of refraining Palestinians from delegating such jurisdiction. Additionally, the object and purpose of the Rome Statute and the jurisdiction regime of the ICC is to respect lawful and de jure sovereignty. So the ICC is supposed to respect lawful sovereignty and not unlawful de facto sovereignty. So basically what we try to argue in our amicus is that the test to determine the capacity of an entity to delegate its jurisdiction is whether such entity possesses a recognized legal authority. And according to international law, such as those mentioned by Ardi, UN resolutions 242, even the UN partition plan, the ICJ opinion on the wall, they all maintain that Palestinians have de jure sovereignty over Palestinian territory.
Mm-hmm.
If we want to add one more thing in relation to that, is also that the Israeli occupation by itself, by its mere presence, it violates the right of Palestinians to self-determination. Mm-hmm. And why is this important? Is because if having the existence and the expansion of settlements in the West Bank, which is the main driver of the occupation, having such settlements is by itself, it's a violation of the right to self-determination. And hence we argue that the right of self-determination is actually a preparatory norm. And according to international law, special agreements are not allowed to be conducted in violation of the preparatory norm, which is in this case self-determination. So what we argue is that Oslo by itself is not allowed to actually violate the right to self-determination. And in reality, by not allowing Palestinians to delegate such jurisdiction, it does forbid us from practicing our right to self-determination. Mm-hmm. So we don't argue that Oslo is void, although some other scholars do argue that, but according to the current situation, Oslo is still in place. However, what we argue is that this specific notion of not allowing Palestinians to delegate jurisdiction is in violation of self-determination, which is a preparatory norm, and hence should not be allowed in practice. So this is the basic gist of our argument. And in this sense, we try to argue that any limits on Palestinian adjudication on our jurisdiction and our right to actually delegate does not necessarily deem the agreement, the Oslo agreement, void, but it rather suspends the obligation to limit such jurisdiction.
Mm-hmm. Perfect. Thank you so much for this insightful reading of Oslo, actually, and I'm sure this raises many questions to the audience. So please feel free to ask your questions online, and in about 10 minutes, I will start, referring your questions to Ardi and Halla. Ardi, I have a broader question. As a tactic, how does the ICC investigation fit within the broader Palestinian multilateral strategy?
Thanks for the question, Noor. First and foremost, I think it's important for us to keep our eyes fixed on the victims of the crimes that are alleged to have been perpetrated in the occupied Palestinian territory by all parties. To be sure, the vast majority of those victims indeed are Palestinian, but we mustn't forget that there are others as well who are impacted. Beyond that, however, I think your question is extremely important because from a Palestinian standpoint, we need to appreciate, just where this ICC situation and this recourse to the ICC fits. Look, there are any number of tools that are usually available to states in international relations for recourse, for grievances, military, economic, political, and so forth. It is of no particular secret, it's no surprise that the Palestinians have very limited tools at their disposal. One of the tools that they have had over some decades now is the multilateral system, by which I mean the United Nations system and public international law. It is, for the most part, the discipline of international law and its requirements on the side, as it were, of the Palestinians, ostensibly at least. The key is that Palestine is trying to tactically make use of various different avenues, if you like, as part of a larger strategy to use law to force a cost on the occupying power for its excesses under relevant international law. As it stands today, there are basically three tracks that the Palestinians have chosen to follow. The first, of course, is the International Criminal Court, and we're discussing that now. One other important track is a track at the International Court of Justice. The ICJ is the principal judicial organ of the United Nations. It is what we call, in general terms, the World Court. It was the court that issued the 2004 advisory opinion on the construction of the wall by Israel in the occupied Palestinian territory, which your viewers will be generally familiar with. And recently, I think it was in September 2018, the state of Palestine brought a case, a contentious case, that is a case against another state directly, that state being the United States, for a declaration under the Vienna Convention on Diplomatic Relations from the court that the move by the United States of its embassy to Israel from Tel Aviv to Jerusalem violated the Vienna Convention, or violates the Vienna Convention on Diplomatic Relations. It's an important case because it's the first time Palestine has brought a contentious case, and it's against the United States, no less. The US position, much like the position of many of the states parties in the ICC case that we're dealing with now, in their amicus briefs, so that would be Hungary, Czech Republic, Australia, Germany, Brazil, I think there might be one more, but there's a group of states who basically argue before the ICC the same thing that the Americans are arguing at the ICJ. They're challenging jurisdiction of the court. They're saying the court has no jurisdiction to deal with the merits of the claim because Palestine is not a state. You can only access the courts, in this case the ICC or the ICJ, the United States. You can only access the ICJ if you're a state, and Palestine is not a state. So there's that angle. And then there's also a third track which the Palestinians are taking, which is taken under the Convention on the Elimination of All Forms of Racial Discrimination, a widely ratified UN Human Rights Convention on racial discrimination. There is a provision in it that allows states parties to make complaints to something called the Human Rights Committee, which is not quite an adjudicative committee, but a committee that oversees the application and respect by states parties to the Convention on the Elimination of All Forms of Racial Discrimination terms. And Palestine brought that just a couple of years ago, maybe a year and a half ago, against Israel. So it's brought a claim against Israel that it's violating the Convention on Racial Discrimination for, among other things, systematic application of racialized laws, apartheid-like practices, and so forth. This was the first time any such mechanism was used by any member state of CERD. So Palestine is at the forefront of, if you like, progressive development of public international law. But these three tracks, the ICC, the ICJ, and CERD, are part of a larger whole, as I said, to bring it around, part of a larger whole by Palestine to try and enforce both a legal cost, but also a political cost for those who are violating the rights of the Palestinian people without let and with utter impunity for decades.
Thank you so much, Ardi. So if we focus on the ICC track, Halla, where do you think would this go? What are the limits and the prospects of an ICC investigation? We know it's not going to liberate Palestine, but what do you think are the prospects here?
Just to begin with your last sentence, that it's not going to liberate Palestine, I think this is one of the issues when you hear about the ICC, especially in Palestinian media. There is this notion as if the ICC is going to liberate Palestine or bring Palestinian, Palestinian rights and Palestinian victims are all going to be remedied. But it's important, to note that this is not going to happen, and that the ICC work is going to be very limited. So where would this go? Currently, since we're waiting for the pretrial chamber to let us know what are the limits or what are what's the territorial scope of the Palestinian state, basically. The pretrial chamber can give us an answer and can basically say that the territory which the ICC has jurisdiction upon is only areas A and B. This is a possibility. Or the pretrial chamber can actually say, no, the territorial of Palestine or what the ICC has jurisdiction on is all of the 1967 territories A, B, and C. However, there's also a third option, which is basically the pretrial can refuse to answer this question. Refuse in the sense that they can basically say that we don't find this issue important to be answered now. Not that it won't answer it in the future, it has to, because when it's at the trial stage, they have to actually engage with this issue, but they can now tell the prosecutor, please go ahead with your case and we won't give you a specific answer on this point. So we need to take that into consideration. But then, so this is the territorial issue. But then what's going to happen with the ICC? My own actually thoughts that there will be an investigation. It's going to go forward. Of course, there's always the issue that we need to keep in mind is that the Security Council of the United Nations can actually stop the work of the ICC for a year. This has to be done through the Security Council for the interests of justice. I mean, we don't know if they're going to do it, but this is a possibility that the United States might push for something like that they would stop the investigation of the ICC for a year, which also can be renewed for another year or so. So this is an option that we need to keep in mind. But what will happen if an investigation actually goes on? Well, the most crime that everyone speaks about that's going to be on the forefront is the settlements, since it's the easiest out of them all, and it's the clearest. As far as I know, there has been a lot of documents submitted to the ICC, whether from the Palestinian side, civil society have actually submitted, some NGOs submitted, the Ministry of Foreign Affairs have given, for the longest time, monthly reports on the issues of settlements and other crimes. So settlements is going to be at the forefront, and then the issue of Gaza as well, killing of civilians and the infrastructure. So my thoughts that eventually we will reach an investigation point where the trial would actually go on, but when is an important thing. And as Ardi said in the beginning, there's no limitation on when this is going to happen. So we don't really know if it's going to happen in a year or 2 or 5 or even more.
Okay, thank you so much, Halla. Ardi, what are your views on the limits and prospects, building on Halla's views?
Yeah, and building on yours as well, I think both of you made some fine, important observations. I mean, there is one of the things that I did want to speak to was the general sense that many in the community feel a frustration with international law and almost to put words into people's mouths, forgive me, the complicity, if you like, of international law and discourse and all of that in the subjugation of the Palestinian people. That cynicism about international law is a real one, and it needs to be spoken to, I think, objectively. And so what I typically say, and I'm critical of public international law, I'm an international legal scholar and practitioner that is also critical of these things, there's also a prospect and a use for international law if used strategically, tactfully, correctly, if you like, to force costs. And there certainly is, it is certainly true that Palestine will not be liberated. The occupation will not come to an end through action at the ICC, or indeed at the International Court of Justice, or at CERD, or through the General Assembly on their own. What the point is to marshal international legal argument to shift a political debate and the contours of a political debate to the point where the costs of maintaining the status quo are politically untenable, unfeasible, unworkable, and therefore must force a political change, right? I'll give you an example. I've just recently written a paper, posted on SSRN, and I'm welcoming your viewers to read it, called Negotiating the Illegal on the United Nations and the Illegal Occupation of Palestine, 1967-2020. And in it, I interrogate simply the status quo at the United Nations, which is as follows. There is this copious pronouncement body of resolutions that identifies all the relevant international law and the violations of relevant international law by the occupying power over and over and over again, year after year. The Palestinian people have a right to self-determination. The territory is occupied. Israel's not sovereign in the territory. It goes on, right? But you always end up with the United Nations, the same United Nations bodies, whether it's the GA or the Security Council or the ICJ or whatever, encouraging the parties to return to bilateral negotiations to end the occupation. Now, that fact in and of itself is a problem, right? Because we know that the imbalance of power between the Israelis and the Palestinians are such that there can never be a bilateral negotiation that will provide the Palestinians even a modicum of justice based on international law, just based on the power imbalance. So I argue in that paper that the better position is to use law strategically, in this case, to seek an advisory opinion of the International Court of Justice that Israel's continued presence and regime of control over the Palestinian people in the occupied Palestinian territory as a whole is itself illegal. And as an internationally wrongful act, the laws of state responsibility do not require the Palestinian victims to negotiate the end of their bondage. Quite the opposite. Because it's an internationally wrongful act, it is Israel who's under a unilateral, unconditional obligation to withdraw from the whole of the territory, right? Mm-hmm. So this is an example of strategic, tactful, if you like, use of international law to force political change. And I would only request your viewers who are cynical about international law and its value in all of this to view the ICC situation and the state of Palestine's turn towards the multilateral order in this sense in those terms. Mm-hmm. It's far more nuanced than the media makes it out to be.
Mm-hmm. Thank you, Ardi. This is very interesting, and I'm pretty sure we will have more questions about the potential use of international law. We actually have 12 questions, so I'm going to start asking you the questions from the audience. So to our audience, please vote because on the question that you would also like me to ask, because given the remaining time we have, I would only ask the questions with the highest number of vote. So Halla, there's a question about how the efforts at the ICC fit into Palestinian civil society goals and strategies on the ground vis-a-vis Israel and the larger political human rights agenda. And given that you are actually based in Palestine and you're engaged with the work of Al-Haq and other organizations, can you tell us more about how the ICC investigation fit into efforts by civil society organizations on the ground?
Actually, in the past couple of years or more, we've seen a little bit of shift in the work of civil society, Palestinian civil society, especially given that Palestine ratified a lot of human rights treaties, including the Rome Statute, of course, but also other human rights treaties. We noticed a shift in some of the work of the civil society, in that they are working more closely with international law. I mean, they've been working with international law, obviously, Al-Haq and others, but we have noticed that they've actually increased a number. So one of the issues that they're working on, for example, Al-Haq and the other civil society organizations actually also submitted an amicus to the ICC. And this has been very important because we need civil society to be engaged in such issues. Other than that, we noticed that some civil society organizations are actually pushing the Palestinian Authority to amend some of its laws to be in line with the Rome Statute of the ICC, since we are obliged to do that under international law. So there has been some work done by the Palestinian civil society towards that end. Also, for example, in the past 2 years, we've noticed a lot of requests by civil society on report writing, whether on how to do it on the international level, whether it's shadow reporting or other means of reporting. So whether it's ICC, I mean, I'm not only speaking about the ICC, but in general, this whole idea of dealing with international law that has been only within specific type of civil organizations within Palestine is now actually spreading more and more. And we've noticed that some organizations are actually establishing international law units within their organizations because they sense the importance of it.
Okay, thank you, Halla. Ardi, there's a question about the role of other states in influencing an ICC investigation. So basically, the question is, how much influence do the US and other European countries, including the UK, have over a decision taken by the ICC to prosecute? Can a prosecution go ahead even if these countries oppose it?
The short answer is yes, depending on the circumstances. Ostensibly, and we have every reason to believe, though there have been some moments where this concern has propped up, particularly on the situation in Afghanistan. Ostensibly, the Office of the Prosecutor is an independent operator. She has, and before her, the gentleman who was the prosecutor before her, Ocampo, the Office of the Prosecutor has been very clear that they operate independently and are very, very firmly fixed on that. You will not have a change in that position, that they operate independently. There have been some academics who critiqued the independence of the prosecutor. There have been some concerns by counsel for some of the parties regarding the ostensible independence of the Office of the Prosecutor. I guess the height, and certainly concerns that states have put pressure on the Office of the Prosecutor and the court to adjust its positions, if you like. And I guess the height, if you like, of that was when, I think it was in September 2018, John Bolton, then the US National Security Advisor in Washington, made it clear that the ICC was, quote, dead to the United States. It was a problem, and it urged that the United States would take action, particularly sanctions on individuals, if investigations were open against the United States or its personnel in the situation in Afghanistan. And it tagged on, I think John Bolton tagged on reference to US allies, by which he meant Israel. Mike Pompeo, the Secretary of State, I think in March of this year, reaffirmed that position, reminded the court that, there would be specific consequences on the staff of the court, and named 2 individuals of the court, to be precise, meaning sanctions would be imposed on them, visas would be denied. Indeed, the travel visa of the prosecutor, Fatou Bensouda, was withdrawn from the United States some months ago. So the US is taking attempts, and other member states are taking attempts to apply pressure. The question is whether or not that pressure will actually bear fruit. There was some concern on the Afghanistan situation when the Office of the Prosecutor had advanced her preliminary examination in that matter to the pretrial chamber seeking authorization to pursue an investigation. And this had happened after the US threats that I mentioned on Bolton. And the pretrial chamber made a decision that although there's enough evidence and there's sufficient gravity and all of that stuff to satisfy opening of an investigation in Afghanistan, the interests of justice, which is an element of the test required to be satisfied to open an investigation, were such that there should be no investigation open against the United States or any of its proxies in Afghanistan. There was some concern with that and lots of commentary on that and the impact of that on the independence of the court. Thankfully, that was appealed, and the court has come back now and allowed for the investigation to be open. So there is a tension that you see. You certainly see it implied in the positions of those states that have filed amicus briefs before the ICC in the Palestine situation, who've argued that Palestine is not a state, even though those states like Germany and Australia are vehement, very vocal historical supporters of the object and purpose of the Rome Statute and of the International Criminal Court as an institution, all because they care ostensibly about the international rule of law. They care about international criminal justice. They care ostensibly about these things. And yet they argue technical points that Palestine isn't a state, and therefore the victims, by the thousands of the occupying powers' excesses in the occupied Palestinian territory should not have their day in court. There's an implied political pressure, if you like, in those flimsy legal arguments, in my respectful opinion. But you see this tension play out at the ICC. It's not unique to the ICC. It's a marked feature of international law. And the hope is that the Office of the Prosecutor will continue to maintain its independence. I think there will be an investigation opened at some stage. And I suppose I should leave it at that before we ask other questions.
Yeah, thank you, Ardi. I think it's not surprising that the U.S. is opposed to an ICC investigation is seeking different ways to stop it, given the strong historical U.S.-Israeli military and political relations. Hala, there is a question about, Benjamin Netanyahu and Gantz, they have formed their unity government earlier this week to push ahead with annexation. And there's a question from Michael, who is asking, how do you think potential Israeli annexation of the West Bank will affect the ICC process, if at all? So would an annexation affect the ICC process, and how?
Okay, so as a general answer, I don't personally think it's going to affect the ICC. I mean, Ardi might have a different opinion, but I don't think it's going to affect the actual case of the ICC, because I suppose that whether the Office of the Prosecutor or the trial chamber, a pretrial chamber, is actually going to look at the lawful sovereignty of the land. And they will not look, they will not consider, they will consider the issue of annexation, of course, but regarding the jurisdiction of the court, they will consider the lawful sovereign on the land, which is the Palestinian state. There will be other issues that might come within the case, but I personally think that the court will consider, this annexation. Hopefully they will not look at it within the crimes. So they will still consider the crimes regardless of what is happening on the ground. Actually, in some sense, I might be wrong, but in some sense, I think it might actually push the court to look into the issue of settlements and other crimes even more, because this says that things are happening on the ground much faster than what's happening at the court, which has been for the longest time. But I think it might actually help the court, help us, of course not help us, but it might help things move faster in some sense. But will it obstruct the court from doing its job? I don't personally see that, as the court and the Office of the the Office of the prosecution was pushing for lawful sovereignty. And I suppose this is what's going to happen as well moving forward.
Thank you, Hala. Ardi, I think this is an important question about the potential annexation of the West Bank. Do you agree with Hala that it would not really affect an ICC investigation and might even push it?
Yes, I think in general terms, that's true. I should say that the reference to, there's a number of points to be made. The reference to the so-called annexation, in international law, there's no magic formula that would indicate that an annexation has indeed taken place. You don't need a formal, if you like, passage of law to crystallize an attempt, in this case by an occupying power, to annex occupied territory. It's a factual question, and I would suggest to you that the facts, as established over the past 53 years, long before any decision is taken by a coalition and government in the coming weeks, have already established that Israel has, in all but name, annexed the whole of the occupied Palestinian territory, either as a matter of law, de jure, or as a matter of fact, de facto. So the crystallization, if you like, of annexation by the current government, a coalition government in Tel Aviv, of huge swaths of the Jordan Valley or Area C or what have you, will serve a purpose, but legally perhaps not. The purpose will, exactly as Hala mentioned, will add impetus, political impetus, if you like, to the work of the Office of the Prosecutor. The issue of annexation as a whole is what international lawyers would typically call a jus ad bellum problem, a problem that goes to conquest of territory as a whole. And that's important because the jurisdiction of the International Criminal Court is to cover the so-called core crimes, crimes against humanity, war crimes and genocide, plus, as of 2018, the crime of aggression. Now, annexation of or conquest of the whole of occupied Palestine would fall into the term aggression. The problem there under the terms of the Rome Statute is the court could not take jurisdiction at all over the crime of aggression committed by the occupying power in occupied Palestine, because there is a unique regime that applies to the crime of aggression under the Rome Statute for its applicability in any situation. And that uniqueness is simply that the party who is alleged to be the wrongdoing party must be itself a signatory to the convention. And in this case, Israel is not. So aggression is out in terms of the situation at the ICC. To the extent that annexation involves appropriation, certain war crimes under the Rome Statute, say, for instance, appropriation of property unlawfully and not allowed as a matter of military necessity, see Article 147 of the Fourth Geneva Convention and Article 8 of the Rome Statute, then the court could exercise jurisdiction over those things. But it is in all likelihood going to be the case that the court needs to narrow its focus on the most high crimes, of which the settlement endeavor and project is part. Not exclusively, but the main part. Annexation, again, adds impetus to the work, but won't fundamentally alter it.
Okay, so just to verify, because there's another question on annexation and how it would affect the settlements issue. Settlements will be a main point of investigation in the ICC. So do you think the annexation by this new Israeli government would impact the settlements issue or affect the ICC's ability to adjudicate? That's one of the questions, actually.
If I might just continue, the answer is it won't affect their ability to investigate, but it will aggravate. It will aggravate the ongoing crime committed by the occupying power, being settlements, right? So this is a crime that is not static in time. It is continuing, and the annexation will be viewed rightly by the Office of the Prosecutor as another element, if you like, in the crystallization of this ongoing crime.
Thank you, Ardi. Halla, there's a question about the role of civil society organizations in the US or anywhere to support the efforts to open an ICC investigation. So the question is, what specific asks or talking points should be emphasized in the lobbying? And are there any networks they should work through? What do you think, given also your own work in this arena?
I think, I mean, to begin with, of course, the whole issue, I mean, we're standing on the territorial issue. This is a good starting point because this is an issue that's being discussed currently. However, other issues are going to come very soon. You know, the issues of complementarity, whether complementarity is basically that the ICC cannot look into a case if people have been tried on the, within national jurisdiction. And all of these issues are going to be points of contention at one point. So I think one of the issues that civil society, whether in the States or in other areas, can look at are these legal matters, because recently we've been actually developing a new generation of Palestinians that are looking on legal matters, but still we are in need of support from civil society abroad. And I think, I mean, there are some coalitions that are starting within Palestine actually that support the ICC, and there are others abroad. I mean, there are a few abroad that I can send you links. But I think one of the main issues is that the Ministry of Foreign Affairs, which is, you know, which is quite surprisingly, they've actually been working on the ICC issue. They haven't been on top of it completely, but at least there's been some progress. And I think that's one way of support, is that submitting documents, whether through the Ministry of Foreign Affairs, because they are in need of some more research sometimes, or actually through speaking to the media. Because I think this is one important thing, whether it's in Palestine or abroad, there's a lot of misinformation on the court on how to conduct and how the investigation is going. So if we can just say there are two issues. One, that yes, some more work, some more work with regard to legal issues is needed, and this might be good to bridge the gaps between Palestinian civil society and those other, abroad, and at the same time, speaking to the misinformation that's being used in the media currently.
Yeah, thank you, Halla. So there's a related question by Amjad. So there's a fear that the members of the ICC pretrial chamber may decide to reject Palestine's case moving forward, specifically after the opinions submitted by several states against the court's jurisdiction. Ardi, what courses of action, legally or politically, can or should be pursued if we reach such a scenario? In your opinion?
With respect to Amjad, I don't think that will actually transpire. Though it is possible, you can never predict with certainty. But on balance, knowing the international law as we do, knowing the position of the international community as demonstrated through, among other things, universal consideration of the territory of the state of Palestine being the occupied Palestinian territory, West Bank, Gaza Strip, East Jerusalem. This is to be seen in hundreds of resolutions of the General Assembly, the Security Council, the principal judicial organ of the United Nations and the ICJ, the Economic and Social Council, the Secretariat, etc. Knowing as well that the state of Palestine is a state as a matter of law, has acceded to the Rome Statute of the International Criminal Court as a state, because only states can do that. Knowing all of those things, it would be highly irregular if the pretrial chamber were to come down negatively, if you like. The pretrial chamber may be silent, as Halla had mentioned earlier. It may offer an opinion to say, look, we don't think this is a relevant legal question at this stage. Please commence the investigation, continue with your work. But in the event, in the unlikely event, it is a negative opinion, there can be an appeal of that opinion, right? You can appeal it. So that it all would not be lost. I'd like to actually return to something that was asked earlier, and it just goes to what other states might do and what civil society on the outside of Palestine might do in places as far afield as Canada, the United States, and other places. States generally have obligations as high contracting parties to the Geneva Conventions, which are the base, if you like, of the war crimes provisions of the Rome Statute, right? That obligation is contained in Common Article 1 of the Fourth Geneva Convention relative to the protection of civilian persons in time of war, which is the main treaty that governs occupied territory. And many of the provisions of that treaty have been domesticated or folded into the domestic law of many high contracting parties, including, for instance, United States domestic law, Canada's domestic law, the UK, Spain, etc. And those states have obligations to prosecute or extradite persons who commit violations of the Fourth Geneva Convention, including, for instance, Article 49 of the Convention. That is the prohibition on civilian settlement of an occupied territory, right? These are criminal actions that violate the domestic law of many of these third states. Civil society organizations need to organize themselves, and I know they are doing, particularly with Al-Haq and others, but to do so with extra vigor to apply pressure domestically to ensure that those states discharge their obligations to ensure that Israel abide by its obligations under the relevant law, in this case, the Fourth Geneva Convention, which again underpins the Rome Statute. Those are things that can be done, right? And that are being done. But I would encourage your viewers to feel, well, this is, don't feel all is lost because this is in the hands of states and elites and global elites. No, civil society organizations can press at the local level and have done in the past with other cases, the Pinochet case, and others, for instance, as an example.
Thank you, Ardi. This was, I hope this was very useful to those from civil society organizations who joined us today. Ardi, I just want to go back to the question of the pre-trial chamber, because there's a question by Bob, which was related to Amjad's question. Do we know who the judges are on the chamber or the panel, which will confirm or deny the decision of the prosecutor? And what political considerations, if any, are expected to influence their decision? I don't know if you or Halla know about the judges.
Halla, I know who the judges are, but I don't know their political proclivities. I don't have that information. Halla?
Okay.
Yeah,
Halla.
actually, me too. I mean, of course, there are judicial divisions, and we know which division Palestine will be, the case will be looked at. But I'm not sure about their political.
It's a matter of public record. All you need to do is go to the ICC website and open any of the amicus briefs, including the fine one done by Halla, and you'll see that Judge Peter Kovacs, Marc Perrin de Brichambon, and Judge Alpini Gansou are those who are responsible. I have every confidence that they will discharge their obligations independently. I have every confidence that as judicial officers of the ICC, they are sworn to those duties, and we should expect them to uphold those duties. There's no reason to think that they wouldn't.
Okay.
Yeah, don't be so cynical, friends.
Don't be cynical. Halla, Ardi in his talk, he talked about 3 tracks that Palestinians are pursuing, including the International Court of Justice. And so there's a question by Suzanne Akram, who is asking why could you speak about the reluctance or failure of Palestine to follow up on the 2004 ICJ opinion with a second request for an advisory opinion to the ICJ. Do you have any idea why Palestine failed to do so, Halla?
Yep.
I mean, partially this is also a political question. I mean, and the issue of following up on the ICJ opinion. I mean, we do have an advisory opinion on the wall. There was this question of whether we should have a second advisory opinion related to settlements, because they did mention the settlements in the advisory on the wall, but some people were pushing for another advisory opinion. However, there is this issue of the internal political issues within Palestine, which is also not only related to the ICJ opinion, also to the Goldstone report. This was also, there was this question of why hasn't there been a push regarding the Goldstone report? Why didn't we ask for, whether the Human Rights Council or a General Assembly resolution, something with more, with more implementation, if it exists. So I think partially this is a political question, and because the Palestinian Authority, with such moves, there's always this issue of negotiation with the Israeli party. And so the question is, if they go through that, what would happen from the Israelis? And we noticed that sometimes the Palestinians would stop from going forward with such issues because they're expecting something from the Israeli side, which is sometimes regarding whether it's money or some other things, especially now with all the ongoing issues that's going on. So I think this is partially a political issue that Palestinians are leaving for negotiations on and off, and it's an important question. But also my cynical part is, what would another advisory opinion really benefit us? I mean, okay, the first one was very important. We use it, the whole world uses it in different aspects, not only in regards to Palestine, but why would it be important to have another advisory opinion on similar issues?
Mm-hmm. Thank you.
Yeah, that's actually a really good question. And with your permission, Noor, I'd like to actually take it up.
Please.
Only because it's fresh in the mind. That paper that I'd mentioned is part of a larger book project that I'm working on, and I urge in that paper that Palestine should return to the International Court of Justice for a second advisory opinion. I'm not the only one to have done that. the current special rapporteur on human rights in the occupied Palestinian territory, Michael Link, has done so in October 2018, I think it was, or 17 rather. What would be the added value? It is true that the 2004 advisory opinion pretty much affirms all of the relevant law, if you like, that has been affirmed by the principal political organs of the United Nations, being the General Assembly and the Security Council, over many decades. The illegality of the settlements, the existence of the Palestinian people as a people, their right to exercise self-determination in a territorial unit that would be a state, being the occupied Palestinian territory, the illegality of the wall, all of those sorts of things have been affirmed. You'll recall, you may or may not recall, that in paragraph 162 of the 2004 advisory opinion, the penultimate paragraph, after having made all of these statements or affirmations of the illegality of these discrete, independent, individual acts of the occupying power, the court urges the Palestinians to go back to the negotiating table to end the occupation. That urging, if you like, made the whole opinion fall flat in its face, right? Because the Palestinians can't enforce international law on their own. They need other states to assist them to do it. And if the other states are saying you must negotiate the end of this illegal situation, but you have no ability or wherewithal to do so, as demonstrated by the historical record, then what good the opinion? A second advisory opinion, if the question was properly, if you like, drafted, and if the issue was properly isolated to the following, in my respectful view, what is the legal consequences of Israel's continued presence in the occupied state of Palestine, right? Then you would focus on the one thing that the international community has yet to definitively pronounce on at the UN, the legality of the very regime of Israel's continued presence in the whole of the occupied state of Palestine. If that whole regime is illegal, then it cannot be brought to an end through negotiations. It can, but there's no legal requirement in international law that its end be brought about through negotiation. Rather, its end must only be made through unilateral withdrawal that is unconditional. Of course, the Israelis would not do it. Nobody's under any belief that an opinion of the International Court of Justice would cause the Israelis to see the light and leave the territory unconditionally. But what it would do, such an opinion, is alter the political discourse, the calculus, the calculations within the United Nations of what is required of the subjugated Palestinian people to end their predicament. Mm-hmm. That is key. That is politics. That's why I think a second advisory opinion is useful.
Thank you, Ardi. And I think we can share the articles that you wrote and that Halla wrote with the audience on the bar. So Megan will do that because we referred to several articles. We're running out of time, but there is one last. We actually have 13 more questions, but unfortunately we don't have the time to address them. There is one more question that I would like to ask you, Ardi and Halla, to conclude, which is what impact do you believe a successful ruling at ICC would have on the Palestinian struggle? Halla, maybe we can start with you.
So what impact would it have on the Palestinian struggle? I think from one aspect, the Palestinians really need a win. And it's important for the morale and, as mentioned before, there's a lot of cynicism around international law, a lot of mistrust, and it's rightly so in so many ways. But I think if, having something that actually, where we feel, it's not only UN resolution, it's not only an ICJ advisory opinion, but it's rather a case at the ICC that says, there's actually crimes that have been committed. There have been Palestinian victims. I think this would be good in general for the Palestinian morale from one aspect. And it also would encourage Palestinians to be more creative, whether with international law or other forms, For example, the third committee complaint that Ardi mentioned. I think it was important that we are looking for other venues. I mean, now some other discussions are, are taking place on what else can be done with, complaints or other forms of issues. So from one aspect, I think the whole ICC would open up other forums for Palestinians, and it would help us actually think outside the box of, okay, so international law is not that, hasn't been that good for us, but maybe we can think about, looking at international law from another, point of view. But at the same time, I think it's also important, from another completely point of view, I think it's also important to go on with international law with some cynicism is actually good, because I feel that a lot of times we put all our eggs in one basket, and this has been happening recently, with this whole issue about the ICC and its importance. It is important, but it's not the most important issue within the Palestinian struggle. So it might have some benefits within, asserting Palestinian victimhood, asserting Palestinian rights through a court, but at the same time, whatever fruits going to come out of it's going to be, not as large as we think they are, and we need to keep that in mind.
This is incredible. This is very important. Thank you, Halla. Ardi, do you have anything to add regarding the impact of a successful an ICC investigation?
Yeah, the impact, I think, is demonstrated already by the amount of effort that is being brought to bear on the Israeli side and friends of Israel to stop the case. That demonstrates that a nerve has been hit and touched, and rightfully so. We must be realistic with what we can expect at the International Criminal Court, indeed through the use of any multilateral body, whether the General Assembly, the Security Council, international law as a whole. If your viewers take anything away, take the following away: that law is but one tool in a toolbox that all people, not merely the Palestinian people, but all people who suffer from violations of their rights and so forth, must have recourse to. It is the attempt to liberate the Palestinian people from their predicament is not to be found through any one or single one of these tools. But taken collectively, like a multifaceted diamond, if you marshal the tools that you do have, whether civil society pressure, the BDS movement as a whole, cultural pressure, political pressure, economic pressure, and legal pressure, these things collectively can lead to a change. There's no guarantees, but what is guaranteed is that if you forfeit any one of these useful tools, particularly if they're there for the taking, then you only have negative things, and you only have a negative result when there really is no real prospect to use these things. So I would encourage people to think critically of international law, yes, sometimes even cynically, but also creatively more than anything, on how these principles of normative principles of relations between states and peoples in the world can be used to just ends, and in this case, to ensure justice for all victims of war crimes, crimes against humanity, etc., everywhere, not merely in Palestine or Israel, right? But for all victims, right? The universal application of these norms is what matters, and Palestine stands at the forefront of the claim that this stuff should be universal, right? So, keep
Thank
hoping.
you. Thank you, Ardi, for your insights. Thank you, Halla. You definitely raised so many questions for me with no legal background whatsoever, and for the audience. I'm so sorry I can't ask the 13 remaining questions we have, but we hopefully will share with you on the Al-Shabaka website the articles of both Halla and Ardi, and then we might actually have another policy lab to follow on this one. But thank you really, Halla and Ardi. The ICC investigation is a very important hot topic and tactic that is pursued by the Palestinians. We talked about the status of the ICC investigation, and we addressed two main issues: the stated issue and the limits of Oslo. We also talked about other tactics Palestinians are following, including the ICJ and the Committee on the Elimination of Racial Discrimination. And as Ardi just eloquently stated now, this is just a tactic or two, or law is just one tool among many that we should collectively and simultaneously use as Palestinians in order to impose a legal and political cost on the Israeli occupation and its settler colonial enterprise. I hope that the discussion of the limits and the prospects of an ICC investigation was insightful to the audience. We mentioned that one of the main issues is that we don't actually know when an investigation can take place, so it might actually take a lot of time, but hopefully something will come out of it. We also talked about the role of civil society organizations in Palestine and abroad, and working together to push states to push Israel actually to abide by its obligations. That's one thing that can be done among many others. And we also discussed the potential impact of an annexation of the West Bank on the strategy of on the ICC investigation. I would leave you with what Ardi, with Ardi's message at the end. Law is one tool that we should use, but not the only one. So let's think collectively, given our different backgrounds, of what we can do, how we can use cultural boycott, economic boycott, political strategies, and legal strategies at the same time in order to impose a legal and political cost, as I said, and put an end to this brutal occupation. Thank you so much again, Ardi and Halla, for your participation, for your insights. I really learned so much. Thank you for the audience who joined us. Thank you for your questions. And please don't forget to donate for Al-Shabaka if you want us to continue on having these policy labs. Please keep safe and healthy and sane in these difficult times. And I will see you hopefully next month with another policy lab on a different topic. Have a wonderful day, everyone.
Thank you, Noor. Halla, thank you.
Bye.